exhausted the remedy of appeal before the appellate authority?
My lord, I have filed IA that was allowed, but before the government,
Is it your case that the DGP has suo motu reviewed the earlier order? Or you have preferred the appeal?
order was passed by the DIE was.
One is IG has to call for record and he can't take a decision. Sorry, Deputy DIG has to call for records and he can't take a decision. He has to pass over the file to the IG. Dismissal is not a speaking order. Now takes. Compulsory retirement is not a speaking order. See his explanation. Putting up to increment will stand.
That has also been gone into perhaps not as yes. Yes, punishment तो हो गया ना तो
काट लिया था
वो
He has spent his force. Yes, sir.
Five ka sec.
Five application. Compulsory retirement is after holding inquiry.
My lord.
Inquiry. What was the post held by him?
Inspector of Police.
You are not exhausted the remedy of appeal before the appellate authority?
My lord, I have filed IA that was allowed, but before the government,
No, that what happened to the appeal? Appeal was
rejected by the state
pendency of the writ petition.
petition, my lord.
That was allowed.
My lord. That is on the record, my lord.
So punishment is withholding of increment.
Punishment was awarded, my lord. Yes, my lord. The first was
First compulsory retirement.
first I was awarded forfeiture of increment, my lord. Then the DG police reviewed the order under 853 of the police manual and passed the order of compulsory retirement. So I challenged the order of compulsory retirement, my lord, before.
Now where is the DGP order?
DGP order is, my lord. Annexure 9 of the writ petition, my lord, at page 64.
Page 64.
My lord.
Notice.
Writ petition, my lord.
Why I should not? Rule 853.
Is it your case that the DGP has suo motu reviewed the earlier order? Or you have preferred the appeal?
Order was passed by the DIE was there, my lord.
What initially the punishment order has been passed by whom?
DGP.
DGP.
Original order was passed by DIG, reviewed by DGP.
Approved by.
No, reviewed by lord.
By.
Reviewed by.
Suo motu reviewed.
No, IG Bhagalpur wrote that punishment should be enhanced. So the DGP,
The case that before reviewing the punishment order, you have been noticed?
yes, my lord.
Here.
Police manual
Yes,
853A. Why we should not enhance the penalty? On 24/6 was given asking the judge. Explanation has been considered in this. This is by IG.
This is by Bhishma.
Here it is. Call for any file.
No, IG, on the recommendation of IG, it has been placed.
Correct. But he should. Deputy Inspector General may call for file and refer to the IG. No, there is IG order.
This is from the
Harish,
Mahandesh. This Mahandesh.
yes, State Council. There is power of so pass order.
853A, the
853A consisting of two things.
Correct.
One is IG has to call for record and he can't take a decision. Sorry, Deputy DIG has to call for records and he can't take a decision. He has to pass over the file to the IG. And IG is required to pass. Now how DGP has exercised power?
no, my lords, here it says that when an appeal, earlier, my lords, when the rules was framed, Inspector General used to be the highest authority. Now, my lords, the DGP has become the highest authority.
Then where is the amendment?
Here,
3.
Here, my lords, if your lordships will see rule 853AC,
C.
C,
Ah.
it says that when an appeal has been filed and the Inspector General on application of his mind,
One case is not relating to appeal. It is the suo moto action by the Inspector General calling for the record.
no, my lords, one fact perhaps is missing. He has filed an appeal before.
Appeal is also there. He has filed appeal. During pendency of the appeal, Deputy Inspector General exercised the power under 853A and called for the record and forwarded the papers to the DGP instead of IG.
Facts need to be corrected, my lords. It is not during the pendency that he has exercised. My lords, the DIG was the disciplinary authority. He has passed an order of penalty, whereby, my lords, with regard to charge number 1, it has been found to be proved. Charge number 2 was not found to be proved. And therefore, a punishment was awarded of stoppage of 2 increments, which was equivalent to giving 3 black marks. against that order, he went in appeal before the Inspector General of Police. That appeal was heard by the Inspector General of Police and thereafter it was dismissed. At the
Dismissed
time,
on what date?
recommend kar diya. While after hearing the appeal, he found that the punishment which was awarded is less. So he referred the matter recommending that the
So,
punishment need to be.
So on his appeal, he has recommended.
On his appeal, he has recommended, my lord.
Then you show us in the appeal, appellate authority power to refer the matter to the.
That is why, my lords, I was placing 853 AC. When an appeal has been filed and the Inspector General on application applying his mind thinks that he should enhance the punishment, he can dismiss the appeal, but must simultaneously mention in that order that as per power given in 853A, he has decided to review it for enhancement and take action for obtaining a show cause, etc., wherever is necessary.
This is on appeal.
Yes. So he has taken a, he has recommended.
Now where is there that he is required to recommend? Such a recommendation is available for suo motu review, not for appeal.
No, even in appeal, my lords,
Show us.
even when he thinks that the appeal is not to be allowed, then he can dismiss it and recommend it for enhancement of punishment under 853A. Now 853A, there is also a suo motu power of the expert. My lords, earlier the Inspector General used to be the highest authority.
Correct, as long as 853.
Nomenclature is
All right, unless and until rule 853A is not modified.
is equivalent to the, that I can show, my lords. That I will show. That I will show. That there must be some notification where, my lords, this equivalent to DGP that would be there. Now, what has happened that on his recommendation, the DGP considered the entire facts and matters, and thereafter show cause notice was given. And thereafter the DGP
Explanation. Whether explanation
For example, I have taken A, B, C contention. How can I? Not a speaking order, no? Has he given any point wise or something? Document, you see?
Where is your explanation?
My lord,
Where is your explanation?
explanation dated 24/6/2013.
What was your explanation before the DGP?
page 54, my lord,
54.
yes, 261.
Yes.
You see? Yeah, grounds.
Mr. State Council,
my lords,
penalty of dismissal is not a speaking order. Now takes. Compulsory retirement is not a speaking order. See his explanation. Show us from DGP order how the appellant's explanation has been considered.
my lords, his one explanation was with regard to the fact that he
No, sir. So
medical.
yes, he has cited Supreme Court decision. Where is the consideration by the DGP? What is the object of providing notice and seeking explanation? Is an empty formality, is it?
His explanation runs in 10 pages.
And he has cited Supreme Court
For
decision.
judgment. And the impugned order has been passed.
Whether it may not assist him, but DGP has to analyze, no? whether it is applicable to the petitioner case or not.
He went to the extent.
My lords, one of the,
He went to the extent only that charges have been proved on the basis of preponderance of probabilities and therefore positive.
true, my lords, what has happened, but in the previous paragraphs, he has dealt with the defense which he had taken. My lords, where the defense primarily was that the person who has reported about him taking bribe, my lords,
They are not on merit, sir.
that confidential statement which he has given, but on that date, he could not appear and could not cross-examine. So therefore, he was saying that the charge of bribe, which was the second charge, was found to be not proved. Now, the show cause notice which was sent on the recommendation of the IG was that even that second charge of taking bribe stands proved because it was corroborated by a statement of a witness. And that witness, he was saying that I could not cross-examine. Now that was analyzed, and in that it was held that his evidence was taken, and on that date he was intimated with regard to the taking of evidence, but he did not, in fact, deliberately come on that date, nor he subsequently asked for any his re-evidence for taking.
No. I had filed my lord petition before the inquiry officer for giving me opportunity of cross-examining those witnesses. At the writ petition, I have annexed at 30.
And it was stated that he was medically unfit. He said produced certain certificate. Now that was examined by the DGP, and my lords, I'll read just one paragraph where this fact has been examined.
36 and 37.
आरोपित के विरुद्ध लगाए गए आरोप में प्रथम आरोप, my lords may see just the previous page
Yes.
of the order of the DGP where he has examined this fact. आरोपित के विरुद्ध लगाए गए आरोप में प्रथम आरोप पुलिस उप महानिरीक्षक मुंगेर क्षेत्र मुंगेर ने पूर्ण रूप से प्रमाणित पाया है। आरोपित के द्वारा चिकित्सारत होने के प्रमाण के लिए दिए गए तथा कथित चिकित्सीय कागजातों की भी समीक्षा की गई और पाया गया कि इनके द्वारा प्रस्तुत प्रथम चिकित्सा केंद्र बढ़िया का चिकित्सा पर्ची में क्रमांक 20575 दिनांक 10/7/2005 अंकित है एवं अगली चिकित्सा परीक्षा की तिथि 11/7/2006 अंकित है, जबकि बढ़िया थाना पर हुए घटना दिनांक 10/7/2006 की है एवं पुलिस अधीक्षक लखीसराय के आवासीय कार्यालय में घटित घटना 11/7/2006 की है। इससे इनके द्वारा प्रस्तुत किए गए चिकित्सा कागजात की प्रामाणिकता संदेह के घेरे में आ जाता है। दूसरा तथ्य जो इनके दावे कि ये दिनांक 11/7/2006 को चिकित्सारत थे तथा पुलिस अधीक्षक लखीसराय के आवासीय कार्यालय पर गए भी नहीं को झुठलाता है। इनका स्वयं का चिकित्सा पदाधिकारी के इनका स्वयं का संचालन पदाधिकारी के समक्ष समर्पित अंतिम बचाव स्पष्टीकरण की कंडिका 9 में लिखा गया है कि आरक्षी चालक 151 सरताज आलम के प्रति परीक्षण प्रश्न 3 से स्पष्ट है कि जब वह अंदर रूम में आए तब आरोपित रूम से बाहर निकल चुके थे। आरोपित के द्वारा अनजाने में की गई स्वीकारोक्ति से भी स्पष्ट हो जाता है कि वे वास्तव में दिनांक 11/7/2006 को पुलिस अधीक्षक लखीसराय के आवासीय कार्यालय में गए थे, न कि अस्पताल में चिकित्सारत थे। लखीसराय के आसपास उपस्थित आरोपित ने इस आरोप के बचाव हेतु कोई गवाह या साक्ष्य प्रस्तुत नहीं किया है। इनका बचाव मात्र चिकित्सीय पत्रों पर ही केंद्रित रहा है, जो कि पूर्व की विवेचना से संदिग्ध स्पष्ट। तो he has dealt with Millards, of course may not be very satisfactorily, but he has dealt with his submissions, and thereafter the punishment has been enhanced. So far as the petitioner is concerned, he has not questioned the initial order of penalty. That has not been challenged.
Order of penalty?
Order of penalty has not been challenged.
No, we are concerned only with the DGP order.
Enhanced, right. Now
Huh?
now
DGP order is set aside. withholding of 2 increment will stand.
That has also been gone into perhaps not as he has said.
Huh?
He has punishment तो हो गया ना तो
काट
complete
लिया था वो।
He has spent his force.
that has been executed.
All right, we'll set aside compulsory retirement.
No, but this compulsory retirement order, my lords, has been passed after due notice to him.
All right, sir.
Under,
Sir, under rule 853A
my lords,
says that above action should be taken within a reasonable time from the date of final order in a departmental proceedings. Final order was passed in 2009. You have taken suo motu action in 2013. Is it a reasonable period?
my lords, that issue has been dealt with by the honorable single judge, my lords. I'll.
No, we will deal it with reference to Supreme Court decision. What is the reasonable period?
That, my lords, this is in paragraph 6. May I place it, my lords? Submission is made on behalf of the petitioner relying upon the judgment of the court, Ranjan Kumar such and such, being reasonable period, 3 years being reasonable period within which order may be passed in exercise of power under Rule 853A of the Bihar Police Manual. It is his submission that in the instant case, order has been passed by the DGP in exercise of powers under Rule 853A of the Bihar Police Manual about 4 years after the issuance of the order of punishment by the DIG Munger under order dated 22/4/2009. Records of the case reveal that the petitioner was proceeded against for 2 charges. One of the charge was that on 10/7/2006, the petitioner showed rude and arrogant behavior with the Superintendent of Police, Lakhisarai, and tried to make obstruction when he had come to inquire about certain allegations leveled by the people against the petitioner in Janta Darbar.
No, there is delay has been considered.
Yes.
Only submission has been recorded.
No, he has said it.
Para 11?
Yes, para 11. Even otherwise, the petitioner case is not covered by the decision in case of Ranjan Kumar.
Reasonable period has not been taken note of.
Since the facts of the case was essentially different in as much as in the said case an appeal of the petitioner's punishment has been set aside by the appellate authority in that case, in Ranjan Kumar's case. And the DGP had exercised power under Rule 853A of the Police Manual 3 years after the punishment was set aside by the appellate authority. This is not the position in the instant case. This is the, only, my lords, 4 years, my lords, 3, then, even if we, my lords, look to this issue, is not very categorical here, my lords, 853A may kindly be said.
Reasonable period.
Yes, the word is
What is the reasonable period?
reasonable period has to be culled out from the facts of the each case, my lords. It cannot be said,
No, reasonable period.
has to be a particular cutoff.
Reasonable period is 3 months. That is the Supreme Court decision. If a specific period is not mentioned, one has to draw inference that a reasonable period is 3 months.
No, here it is 3 years. That was the judgment, my lords, for this.
3 years.
3 years. But it is, of course, it is not coming within that 3 years also. That I say, see, my lords. But the reason here being, my lords, that
Want to ascertain whether is there any amendment to 853A or not, insofar as giving powers to DGP?
if your lordship will say yes,